So as the recording begins, we are here for kind of an urgent committee session for the Policy Innovation Committee of ISAIL. Um, this committee session by the Indian Society of Artificial Intelligence and Law is specifically being done for drafting comments to submit feedback around the certain clauses which have been recommended as amendments on the concept of synthetic content. These amendments have been suggested for the 2021 IT rules by the Government of India's Ministry of Electronics and Information Technology. Pursuant to that, this session will be chaired by two of our ISAIL members, Advocate Arunima from Bombay High Court and Hamda Arfeen from LegalEase. Both of them are respected patron members of ISAIL. Arunima specializes in entertainment law, media law, technology law, and commercial transactions. And Hamda specializes in legal technology, commercial law, and AI and law. This is an interesting session, but I think it might be short. We have some special interventions from stakeholders as well, including a surprise intervention by Sankalp Srivastav and and Bahadur Shah, Shruti Kakade, who is a co-chair of the PIC, along with Ayush Chandra. Ayush Chandra is not here, but I think Shruti is carrying the memory of Ayush Chandra with us. So I think this session will be sweet and short. I think it should go for 120 minutes, but it can go for 60 minutes. I don't mind. And we have Chakshu Garg, we have Sunil Agarkar, and we have Nisha Singh, in case I forgot mentioning, as ISAIL members. Since this was done in a rush, I don't think we might have a Q&A per se, but I think we can do a conversation, obviously. It should be a conversation, and therefore, since these are community sessions, I will not have any particular view on the suggestions and the feedback per se given to the government on this, but yes, as a community, we can go ahead. So yeah, Arunima and Hamda, please, it's now up to both of you. Please feel free to take up ahead. We have the discussion pointers, but I think we can structure it accordingly. But I think, yeah, please feel free to.
Hello everyone, I'm Hamda. So welcome to this small and short and sweet discussion as said by Abhinavardhan. And yes, I hope there's been this talk around synthetic data and how India AI is taking major legal steps to, transform the whole conversation around regulations of AI. So yes, I would love to hear what everybody has to say about these draft rules, and if we, with this discussion, I hope we tend to form some structured feedback for these draft amendment rules, so that if possible and the time allows, we can, frame something and submit also. So yes, I would love to hear whatever everyone has. Anurima.
Thank you, Hamda. I think, in my opinion, these amendments, it is arriving at a very critical juncture because we all are seeing deepfakes, AI-generated content, which is not only posing risk to the information integrity, but also it is posing threat to the individual privacy and, of course, the democratic discourse, right? Um, I think uh, the government's objective to address these concerns through, one mandatory labeling and the enhanced due diligence obligation is both um, timely and necessary. But in my opinion, if you ask me honestly, I think the implementation framework does raise it raises significant concerns regarding regarding the intermediary liability or the media freedom, and what is the technical feasibility that sort of warrants careful consideration here. I mean, if we look at clause by clause, one they have in they have now introduced the definition of synthetically generated information, and it's quite broad in my opinion. I mean, if you look at the definition today, it is they're saying any information that is artificially or algorithmically created or generated. This is the rule 2.1. Sub rule is WA. So anything which is artificially or algorithmically created, generated, modified, altered using a computer resource in a manner that such information reasonably appears to be authentic or true. Now, this is the definition's breadth, and it creates, significant uncertainty for intermediaries. I mean, the phrase reasonably appears to be authentic. If you just take that, it is inherently subjective and it lacks the objective criteria. What is authentic? We don't know. This vagueness then places intermediaries in a position where they are. They have to make the judgment calls about what synthetic content could potentially expand their liability, which could go beyond the safe harbor protections which are contemplated under Section 79 of the IT Act. Now, if we go back to the Shreya single matter, right? The court had clarified that intermediaries should not be required to exercise their judgment over the content, but it is in absolute contradiction to that judgment today. Because if you are asking the intermediaries to sort of assess the authenticity and the appearance of content, it precisely requires them to make certain judgments. I think there should be some sort of a technical standard or criteria uh, to understand what is authentic, and how do we you know say that some content appears to be authentic, and what would be deemed as synthetically generated content, which is also based on the verifiable technical characteristics. I mean, are we talking about use of generative AI models? Are we talking about algorithm? Are we talking about some sort of modification parameters, rather than this being very subjective? Over to you.
Yes, I completely agree with what you've pointed out, Anurima. I mean, I also was of the same opinion that there are no clear distinctions as to what will be synthetic or what is reasonable, and how these who will actually look into what data is synthetic and what is not. And yes, these of course, I mean, it's a very major step and a very quick step rather, with regards to India taking a stand for the synthetic content, and bringing up about these draft rules. So yes, if anybody has something to add forward to this.
Yeah, hi everyone. So, just adding on to what Hamda you were saying, and Arunima regarding the subjectivity of detection, right? So, like, since we are all on the internet, and my generation, and myself at least, we are introduced to meme culture, right? So, one of the popular unofficial benchmarks for AI deepfake generation is Will Smith eating spaghetti. And from that era to like right now, what we're seeing, just um, saying what is fake, it's so hard, right? And you need to be kind of in the ecosystem and kind of exposed to content on a linear level to kind of have that psychological way of telling whether this is AI generated, right? So one day, okay, it's the fingers that are this one finger extra. The next day you are looking at lighting, and okay, there is some corner of this, the sun is not landing properly, so this is like a AI generated image. So psychologically, you have to do these tricks, but as it's getting more complex, it's hard to put that kind of energy in, right? And it's not just even from a technical standard. Also, the issue, what we have is um, it's an open problem in technical AI governance. So I think Shruti will be able to add more to this, but the thing is, all the methods we have different combinations, right? Some people are trying to make watermarks, other people are having metadata standards. The issue is any of these can be manipulated. Even if you have like a physical, like a original image, all these when you upload things to social media. So this is mainly on social media intermediaries, right? When you're uploading to social media, there is some compression or transcoding that happens, and the image gets altered. So even the automatic generated techniques, it's very hard for it to like identify if it's AI or if it's someone else is making it. So that's the issue.
And just to add to that, what you just mentioned, Bahadur, I think we all have that common practice of color correction or cropping, or sometimes we do that audio cleanup especially in journalism or where we are doing news or current affairs content. Okay, even when I have to upload certain videos on my handle, right, I have to do that cleanup, which does use AI. Now, this definition has a particular challenge because then it blurs the line between editorial enhancement and the synthetic generation. Because, what is digital editing might not be really synthetic generation, what I'm trying to say. I mean, I'm just trying to enhance and process certain images and videos. I'm not, bringing in a video which is AI generated or something which is not real in life. So, if I go by the literal reading of this definition, what really constitutes algorithmic alteration to make that content different from its raw form is very blurred at this moment, and there has to be a certain carve out to have a legitimate editorial practice, which is also recognized by the journalistic standards of India. I think that's something that the government of India should definitely consider adding.
In
I
fact, to
mean,
just so sorry, I really apologize. In fact, to add to that point, another problem with the definition is that the reference should be to a generative AI application rather than all AI applications. There have been AI applications even on applications like Canva as an add-on, which have been pre-generative, like NLP and other things, which do not genuinely create or even give a modicum of what we call as synthetic information. So, and that was a problem in the 2024 METI advisory of March the 1st, which they sent it to people at 12 a.m. or something. That the problem is that, again, they, like Arunima said, they did not define what is an algorithm. And the problem is California also came up with a similar law. You can't, however, regulate an algorithm as a technology, but you can regulate it as a product. You can regulate the content, but then you can regulate the technology itself, because then it's a very, and it's a similar problem with the EU, right? I mean, they also give us some 200 plus list of kind of generative AI, saying that, these are different kinds of generative AI, we'll regulate them. Turns out the EU is facing an issue because, for number one, they are not binding under the EU AI Act, and second, they are not even enforceable, and third, they are just impractical. So I think, yeah, it's a common problem, but just my 2 bits, but I'll not add much. I think there are rest of the stakeholders, so I'll let them. But yeah, please. Yeah,
Just
I'm done.
to add what you all have said. Uh, Synthetically generated information, this definition is basically quite wide. It is when it says artificially or algorithmically created, generated, modified, or altered using a computer resource. That also includes deep fake. That also includes what you call it, uh, फोटो को आप जो क्लीन अप करते हैं, all these things are also included in this. So the definition goes too wide. It does not only remain for the AI generated activity, but it also takes care of the morphed images and all that things. Then voice, mixing of voice, and all the things which are a mixing of two voices, that also comes into this. Then overlay pictures. Now, if you just say this, then in today's world, this graphic in movie, what graphical change, उसको टेक्नोलॉजिकल वर्ड एकदम याद नहीं आ रहा है, दैट जो green screen, they do shooting on green screen, and then later on they create other images and all. So that also will come into this definition. we just interpret this definition. So uh, all so movies are also going to be impacted with this. All today's movies.
CGI. Uh, I I agree completely, Sunil sir. I mean, what has been pointed out by everyone with regards to the definition of synthetic synthetically generated content is pretty. It becomes pretty difficult even for social media intermediaries to analyze as to what content is actually AI generated and what actually is not. Um, even with regards to, I think we have a message in the chat. Um,
Sankalp was just talking about
yes.
text,
Why do
so
we never talk about
about,
exactly?
yeah,
True, true. Being in academia,
text
it
is
is
so hard. I feel like, I'm so sorry, but
text.
text is much harder,
I
right? I
com-
mean, it's just
I
there
completely
and to
agree. I
trace.
completely agree.
Yeah, yeah.
With
I think we
someone in
haven't even
academia,
opened that can of worms yet. Yeah.
right. With someone in academia, recently there's been an amendment in Blue Book citation rules also as to how we have to actually cite any content that is generated via AI, and if we've used any AI tools for research. So text is completely a different can of worms. I think we are yet not ready to deal with. Um, but yes, I mean, yes, what has been pointed out by everybody with regards to the definition. But then again, not being overly critical about this step, balanced opinion would be that it's a good first step, an appreciative first step by the government, a very quick step rather. I would again emphasize that. With the amount of content that is suddenly there's a rise in deepfakes and AI generated content, though it's pretty quick uh, for the uh, for the whole for the whole country dealing with deep fakes, women dealing with deep fake issues. So I think it should for some extent can be an appreciative step by the government. And yes, with regards to implementation has always been a question of point in any law whatsoever. um, so yes, anybody else if has any other critical discussion? Yes, Uncle, please go ahead.
Yeah, I just wanted to say, I think like in terms of like if we talk about the effect of this, right? If this were to, let's say, come into play as it is in the current form, then enforcing this, like I always tend to think of the social effect, the effects on society in terms of enforcement. Like, will it be something that will be readily taken up? Like just a thought experiment. It's not something that is readily implementable at the current stage. So to build that capacity, there can be some more information, as Arunima said, there's in building information about what means reasonable. That is one thing. But the reason I mentioned text is because it's a good example of how human in the loop and like other things are coming up where we're using this even as part of our Adobe subscription. We're using this on Canva and we're using it in ways where there's the issue of like it being part of a larger process where humans are. Text is the easiest example. Like you could give something to Chat GPT, it drafts it for you. And in images and videos, where it's being used, that is something that I think, like, yeah, enforcement wise, what I really liked about Abhivardhan's point was that you can regulate the market and the product. And that's where I think the issue will lie because significant social media intermediaries already have a lot of extra due diligence under the IT Act. But uh, sorry if I said a lot of things. I just wanted to talk about the impact of the rules in the current form, right? Like if we think about that, the effect would be to sort of stifle the intermediaries, and these things usually get implemented in a way where we don't really know with certainty where AI is being used. Right now, it's not possible to tell with certainty at all times. That's the issue, according to me. Sorry if I said too many things again.
Yes, please go ahead, Sunil. Please go ahead.
Now, another point is we have talked about the generation of synthetic information and all. Another point is that displaying of or the declaring of the information that this is a synthetic information, right? So 1A, section 5, if you can scroll down, please. Further. Bus. Yes. So it requires the intermediary to give a provision that this data is synthetically generated, right? So let me go through the ABC wise. A requires user to declare whether such information is synthetically generated information. Now, secondly, deploy reasonable and appropriate technical measures, including automated tools or other suitable mechanism to verify the accuracy of such declaration, having regard to the nature, format and source of such information. Now for this also, what we need is, this is also generating synthetical information. Provision is that where such declaration or technical verification confirms that the information is synthetically generated, ensure that the same is clearly and prominently displayed with appropriate label and notice indicating that the content is synthetically generated. Now, in my opinion, calling this as a synthetically generated document, although it is really a good or the required thing, as I told earlier also, in movies and uh, uh, all everything will be synthetic. Now when everything is synthetic, तो synthetically generated का notice ही हर जगह पे आएगा. And in this, if I don't declare, there is no remedy to anyone. As such, nobody is losing anything. ये नोटिफिकेशन के अंदर सिंथेटिकली वो जनरल क्लॉजेज में है कि इफ दिस एक्ट इज नॉट कंप्लाइड तो उसके लिए जो रेमेडी है वो है. बट देन that remedy, whether that remedy, legal remedy, is uh, uh, as required for this particular purpose, वो जरूरत से ज्यादा या जरूरत से कम तो नहीं है. So I am of the opinion that a remedy also should be there in this particular segment, कि अगर ये लेवल से आगे है तो क्या, ये लेवल से कम है तो क्या. As rightly said by Sankalp, text is the another issue. Now, most of the things are synthetically generated text. People are doing their homework on text. People are doing their research work and generating this research paper on synthetically. Now, if you see more than the, I would say 70% of the LinkedIn post or anything, everything is synthetically. So, what happens when then LinkedIn, in there also we have to declare, and this requires you to declare what and what, so from what sources you have created. So the information, I just wanted to put my point that it should be a restricted thing and not to open to all. When this synthetic information is open and for everything, it should have a funnel, and for a particular funnel, a better disclosure should be there. In social media, at one level it's fine, at second level it is not fine, at third level it has to be purely non-synthetic thing. So that is required. So of course, for the beginning, something to start is very important. So once it starts, problems will come up. It can be filtered. It can be improved or further. That is always a good process. But yes, that is the point that I feel that these issues should also be addressed. Thank you.
And adding to that, I think this is perhaps the most consequential provision in the entire amendment. I mean, one place it is stating that the intermediary responsibility shall extend to taking reasonable and proportionate technical measures, which is to verify the correctness of user declarations. Now, if you combine this language with the proviso, it is threatening the loss of safe harbor because it is effectively creating that constructive knowledge standard. If we go back to the Shreya single matter, right? The Supreme Court had specifically held that it requires actual knowledge for intermediary liability, and it did specifically deny as knowledge which is obtained through court orders or government notifications, right? These are vague standards that would the court said that these are vague standards that would force intermediaries to sort of proactively monitor content. Now, if we look at this rule, it does circumvent that judgment because it is mandating that the SSMI has to deploy the verification technology, and they are also liable to detect as evidence of knowing permission. So the logic to me appears that you must deploy a detection tool, and these tools should have detected the synthetic content. And because your tool has detected synthetic content, therefore you had constructive knowledge, and therefore you lose safe harbor. In my head, this is the interpretation, because this transforms the section 79, which talks about actual knowledge standard, into should have known standard, which the Supreme Court specifically rejected. Now, constitutionally also it violates the Article 19, 1A, which is it is an unreasonable restriction on the freedom of speech, because it does create a chilling effect where, as an intermediary, if I over remove content to avoid liability, right? So in a way, you're restricting my freedom of speech, and then you're deputizing private entities as censors. They don't have adequate safeguards, and then you are also imposing liability for technology failures rather than an intentional facilitation of them. So I think what the rule should do is to clarify. There has to be a proviso to clarify that the safe harbor is lost only when the intermediary receives a specific notice, which is via a court order, or let's say a government notification about a specific unlabeled synthetic content, and then it fails to act within the prescribed timeline. Because in that way, it will preserve the Shreya single actual knowledge standard while still incentivizing the deployment of these kind of detection technology. And again, I mean, if I adding to what Sunilji just said, if we look at social media platforms today, and especially the news publishers who are operating on social media platforms, whether you talk about Instagram, whether you talk about LinkedIn or Facebook, this does create a cascading compliance burden, because many news organizations, they have social media social media accounts on various multiple platforms, which serves as a distribution channel. Now, as per this rule, these publishers must declare when their content involves synthetic elements. They must verify these declarations using a detection technology. And if they fail to verify, this chain can then, result in content removal or liability. So, again, if I think about the fact check unit mechanism, which was previously struck down by the Honorable High Court of Bombay in Kunal Kamra case, right? It raised a similar concern about the government determination of content veracity. I mean, while the specific mechanism has been stayed, but this verification requirement could enable similar outcomes through technical enforcement. What happens if a news organization it publishes an investigative report using an AI generated visualizations of data, and they declare this on their platform? So the intermediary then has to have a detection algorithm, and let's say the algorithm falsely flags the entire article as synthetic content because they have used these visualizations. So they will have to remove it to avoid liability, and their appeal to the grievance officer will take next 15 days, right? So by then the value of the news would have already diminished. So I think there has to be an one expedited review mechanism, especially for the journalistic content, and with presumptions in favor of publishers who are members of these self-recognized bodies, and provided they are following the ethical standards as prescribed by their specific, norms or specific rules which are there in place.
Arunima, very apt that you added the issue, regarding timelines, because I feel like with social media intermediaries and media and all, it becomes very important to actually crack down, on these issues, right? So with AI and the technical issues, you have these institutions which are already like constrained to respond within a certain time, plus the lack of you know foolproof ways to tell if this is AI generated content. And you add on to the fact that there are very legitimate use cases also, like you said, right? And that keeps on increasing, especially in advertising media and all. You see a lot of AI being used. You also see the same content if you are printing it onto a physical newspaper, if you're using this AI or other generated content, the same liability is not attracted, right? So like that whole distinction itself feels, like the constitutionality of everything which you mentioned, that's going to be a real challenge for this law, and it's questionable how it's going to overcome that with the current structure.
Yes, very, again, Arunima, very well points put forward. Even Bahadur, I mean, to point out that uh, both in Kunal Kamra's case and in Shreya Singh's case, how these intermediary rules are falling back with regards to meeting the standards set by the courts itself. And also the cascading, of course, I mean, with regards to the journalistic content, a very impressive point brought forward by you, Arunima, that with regards to journalistic content, there needs to be an expedient mechanism where the content checking can be done faster, and auditing can be done faster with regards to that. And yes, again, I think.
And we can also
So
take
this,
inspiration from the, sorry to interject, but we can also take inspiration from the EU AI Act or the, China's regulations which are there in place, right? Because one, the EU has a very flexible approach wherein they do require AI systems to disclose synthetic content, but it does allow them to have a context appropriate implementation, right? You don't have to have a specific verification technology deployed on in place or on your platform or wherever social media account that you're using. And again, Chinese regulations also, they also require similar labeling, but they do give a lot of technical flexibility. So I think if we replace the mandatory deployment of specific verification technologies with the principle-based standard that we as intermediaries must implement measures which are appropriate to the state of technology and the nature of their services. So it will provide a safe harbor for those intermediaries who implement measures that meet industry best practices, even if the individual detection failures occurred, right? And we should also have the government-supported research initiatives to sort of improve these detection technology accuracy before we mandate it as a universal deployment for everybody in the country.
Again, a very good terminology. Principle-based standard is what is required with regards to analyzing or with regards to the implementation of these rules. And Yes, I mean, I also fall on the same opinion that again, these are again a lot of compliance requirements on all the social media intermediaries. They again will have to, with regards to AI governance and after that synthetic content, it's a lot of burden on these small startups. Also, I would say that it's a lot of burden on them also. And yes, any other inputs, Sankalp, Nisha, Abhinavardhan, anything?
Yes.
Just adding on to Arunima's point, see, like you said, I think principles-based legislation is way to go, and in that regards, the proposed amendment hasn't suggested any specific technology as such, right? But I feel like with any AI and these kind of emerging technologies, the issue which we face, and how our laws and policies are structured is that, especially in India, I feel like once something comes on paper, it's very hard to get rid of it or change it, and it just remains like that for so long, right? And I feel for this kind of issues, we need to have that kind of some kind of agile, like governance framework, right? We need to have an adept regulator that keeps on coming up with standards. In that sense, I kind of understand what EU and China is going for. They do have those technocrats who are, able to like select different technologies and leave it as an open, like an open-ended kind of thing. These are the technologies we shall notify from so and so time. But the issue with such a broad principles-based mechanism is that, we ourselves are not really sure what exactly we are asking the intermediaries to do when we say when we ask them to verify the content. I feel that's one risk we are going to run into, while making these systems.
Yes.
And there's one interesting aspect to add. I hope I'm not cutting in between, but one interesting aspect to add is that even if you look at the EU requirement, that 200-page file which consists of classifying AI systems, the problem has been, and that is a similar problem with the California law, regulating AI happens in two ways in tech law. I mean, I can say IP, I can say investment law, I can also say AGI defined as a contractual clause in a Microsoft OpenAI agreement, which is classic contractual strategy. But the two basic ways to regulate AI in tech law, and I'm not referring to IP, I'm not referring to cybersecurity, are data protection or safe harbor law, basically intermediary liability, right? Or some people say platform governance. Now, platform governance is rather one way to do because it is a very executive and top-down approach, and all public laws are top-down by nature because that's the nature of the regulator to do so. And in fact, there's a brilliant paper I cited in my book by Stephen and Bechtold, if I'm right, Stephen Bechtold and others. It's a German paper in English on how regulators are losing capacity. So what happens is that there's a problem of capacity that actually prompts a regulator to come up with something very quick. Like Hamda said, it's very quick. It's actually very quick because there's actually a risk. But the thing is, we also have the draft data protection rules of January, in which they have stated that they can come up with any standard under the DPB. So it is up to them to see, as per the feedback given by us and others, whosoever gives, like whether they would like to keep this mandate under the intermediary liability aspect, which doesn't directly involve data issues, except if they are linking it too much with SPDI rules and saying that it's about PII, personally identifiable information, because that's something through API linkages you can do. But then again, how? Like LinkedIn has a partnership with Hyperverge for government ID verification in India, for example. But if you go the data protection route, then how will you combat which? Because Section 3 of the DPDP comes in, which says that anything which is publicly available information is not PII or personal data. So I think best way for now for them is to say that yes, a technical standard is the way. But then um, I think one thing I suggested in the AI Act.in draft, and I hope I'm not dragging it enough, is that I said that maybe for deepfakes and any synthetic and content, anything visual, textual, I mean, I don't think hardware or 3D printing counts, but let's just say visual, sound, because Sono and Audio just had a settlement with Universal Music recently, which is interesting to see. I want something between our music company and them, which would be funny case law to see. But anyway, that's a joke. Keeping that aside, um, 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 it would be interesting to see how. So we suggested that it should be a repository approach where you create a lot of literacy around these tools and these human ways to manipulate AI content. I think that it creates a sense for evidence law as well, right? Because I'm 100% sure you take it up from a public law matter to a judge, they will not be aware about AI unless they have under, I mean, I think it was section 45A of the Evidence Act. Now it is something else in the Sakshi Adhiniyam. I am not sure which section number. So you need an expert for that to verify also. So I think it will be an issue for the judge. So just adding up if it helps. But yeah. So sorry, I think Sunilji has to add and maybe Arunima has to add. So I'm so sorry for my too fast of an intervention, too long.
I would like to tell, before I tell what I want to say, I would like to tell one thing to everybody, which I have seen here. Sorry, I have taken more time. Sorry, this thing. I think nobody should speak that. Because we are here to discuss. And when we discuss, at times you take more time, at times you take less time. So it is always advisable for everybody to not to speak such words. थोड़ा एडवाइस हो गया, इट्स फाइन. ऐसा नहीं बोलना चाहिए जो मैंने भी बोल दिया जो थोड़ा एडवाइस हो गया करके. Now let me come to the point which I wanted to say. See, this amendment is specifically aimed to stop the or to minimize the reducing this spread of misinformation, then reducing the cause of harm to the user, manipulation in elections, then impersonation of individuals and other things. For that, this is prepared. This is the aim of this amendment, basically. So the draft aims to strengthen the due diligence obligations of the intermediaries. The goal is this, to protect the users. Now it is to aim, the aim is to strengthen the due diligence obligation of the intermediaries, particularly social media intermediaries and significant social media intermediaries, such as for platforms that enables the creation or modification of synthetically generated content. Now this you will not see in this this thing. This is a part of the notice, which was also of the 22nd October 2025, where this feedback is invited through this notice. So when intermediaries are responsible for this, yes, this notice. After IT rules 21, you can please highlight. The draft aims to strengthen the due diligence obligations of the intermediaries and particular social media intermediaries, and this as well as for the for platforms that enable the creation or modification of synthetically generated content. Now these are two locations which are required, which are controlled by this. This is the aim. If this is the aim, but it is not declared in this amendment that only these people are going to be affected with this amendment. It is a blanket amendment. So it is just whatever the clauses which are given in this amendment, they are open amendments. So that goes into everything, and complete act is complete act is it is modifying the complete act, and the whole impact is going to be there. But here this narrowing down is required. Of course, as I forgot who said, I think that startups, they may face problem. For that, of course, some of the points can be done, but then declaring that also increases lot of uh, unwanted people. Means suppose I have a capacity of being out of this startup, even though what I will do, all my 5 partners will make become one different startup, and we will do that activity, so that will get multiplied. So to that is all. I think what I am trying to say is कि अगर एक लेवल से कम वॉल्यूम रखने का भी अगर रिस्ट्रिक्ट करते हैं, देन पीपल मिसयूज इट बाय रिड्यूसिंग देयर ओन साइज. So that is also not advisable. But if this is only restricted to these platforms like intermediaries and the social media intermediaries, then there is quite a good thing. But even in that, in social media, if you declare this deep fakes and all the points, then social media would not accept it, would not go for it. So are if we implement, and the Indian social media or the if they implement, will the foreign social media implement it? Because the biggest impact is going to be Facebook, then WhatsApp, अपना WhatsApp University, not even WhatsApp University is going to be impacted, then LinkedIn and Instagram. All these are, there are a lot of new medias which I am not able to recall that names. I have only seen that. Then वो Q के ऊपर से कुछ आपका कोड क्या आता है. So all that things. So in my opinion, we while implementing this, focus on these people should be identified, which is not identified in the notification as of now. This SSMI and SMI and obligations to intermediaries. Now, identifying the fake identity, fake this thing, then implementation of this technology, whether this technology is available and available to all intermediaries who can implement it. That is one of the point, because if it is not technologically, if it is not possible, and if you bring it in the law, then that has no value as such. So, and who is going to regulate it? Whether the original act is going to regulate it, whether the if they are going to regulate it, then whether it is going to give the remedy, because if these amendments are not going to give us the right remedy, then these amendments will not serve any purpose. So and even if it is made like मुझे आप यार याद करवाओ मेरे को, क्या मोल निकल जाता है, फिर वो काले हो तो फिर भी गोरे बन जाते हैं, ऐसा जो फोटो में एडिशंस जो आते हैं, तो मुझे उसका नाम नहीं याद. तो ऑल सच थिंग्स, so that is also synthetic data, synthetic information. So all such things also will have impact. So whether government is inclined to give impact to that, and what if I am uploading that photograph, मैं मेरी मूछें निकाल दूं, बाल काले कर दूं, बहुत सारे बाल लगा दूं, और फिर मैं अपलोड कर देता हूं, ठीक है. Now whether I'm, again in law, men's-ry is very important thing. So whether I am doing it to cheat others, and if I am doing it for that, then yes, intermediaries are made responsible. But whether intermediaries will be able to identify कि ये सब सही या गलत है, whether their technology is available. So that is my point to put it.
So, just few points from my side. Hello, Chakshu, this side. So right now, as like definitely everyone has already pointed out that the rules, like the policy is very vague in nature and it's very subjective as well. Definitely, I can understand the pain points from the policymakers as well. And initially, whenever any policy gets created, they try to like keep it subjective and like broader as well. So, which is understandable. But definitely, there is a room for improvement by making it more objective. And one of the way could be that right now we are not talking about what type of, let's say, solution or model is utilized for generating the synthetic content. Right now we are talking only about the synthetic content only, right? And there is a very broad definition that there can be like n number of possible solutions to create that synthetic content. So maybe to objectively like define it, they should have also highlighted that, let's say, generative AI models which are utilized to generate synthetic content, and then the definition of that synthetic like generative AI model should also be provided to us, so that we can like specify that these rules or policies are only applicable to, let's say, a particular type of synthetic content which is generated through, let's say, XYZ kind of a model.
And to add on to what Chakshu just mentioned, the 10% visibility requirement also, it possesses a very severe practical challenges. Specifically, if we talk about the media publishers, because for visual content occupying 10% of your screen space with synthetic content, a label has to be highly intrusive and it could interfere with the with the viewer experience, accessibility, and can make the content commercially unviable for advertising supported media. And it can also stigmatize the legitimate uses of AI media production. I mean, new organizations and small startups specifically, they increasingly use AI for legitimate purpose. They want to do the transcript automated, they want translation automated, they want data visualizations, they want graphic generation for explainers, and a prominent 10%, a label which is covering the 10% of every AI assisted graphic or visualization would undermine the utility of these tools and potentially would also mislead audiences in believing that the substantive part of the content is unreliable. And for also for the for the audio content, if the initial 10% duration, if we look at it, it is similarly problematic because in a 60 seconds news bulletin, or if I talk about Instagram reels or any sort of 6 seconds of labeling and um, uh, any sort of labeling announcement would significantly disrupt the flow, and also the professional presentation of that content. So I think the another recommendation that I would suggest from my end, it would be to replace the rigid 10% requirement with something more flexible and which is more context sensitive standard. I mean, for a high risk content, which is related to some sort of political discourse or some sort of public figure, maintain a stringent visibility, but for, something which is informational, something which is an educational content, permit a more subtle disclosure. And then again, we do also have the industry regulatory bodies like ASCII, IBDF, AAAI. So allow them to develop sector specific labeling guidelines which are subject to regulatory approval rather than having a blanket mandate for everybody irrespective of which industry they belong to. Also, if I look at it from a tech perspective, there are technical challenges as well when we talk about when we look at these requirements. Um, I mean, look at the if we talk about the metadata permanence, so the requirement for a permanent metadata or identifier that cannot be modified or suppressed is technically very ambitious to my head, because if we look at the research, it shows that both visible and invisible watermarks can also be removed or manipulated through various techniques. So I can compress my image, I can do a format conversion, which often strips away the metadata. So and also the sophisticated adversaries can also use adversarial machine, which can learn to remove impercept, non-perceptible watermark. And then again, simple screen capture or recording can also bypass the embedded identifiers. Now, these are something that the rules should take into consideration. And also, if I talk more specific to the Meta's watermarking experiments, because I'm using Meta and LinkedIn most of the time as a social media account. So I think they do show promise, but they also acknowledge these vulnerabilities today, and the requirement for an absolute permanence may be technically unattainable with the current technology. So this is, to me, it's an arbitrary threshold which lacks technical justification. And I think even the EU AI Act, and Abhivardhan, please feel free to correct me. Even the EU AI Act requires a clear disclosure, but does not mandate a specific size requirement, or it does allow, more technical and a contextual flexibility with respect to images, videos, audios, and because watermarking maturity varies significantly across these modalities. And coming back to the text watermarking, it is relatively more nascent, but audio market watermarking is and audio market watermarking is still there, and then requiring immediate compliance across all modalities may be premature at this stage.
Yeah, nothing to interject. Actually, they don't mention anything like a 10% or something. So yeah.
No, they do. They do. If you go to rule 3, let me share my screen with you to do. 1 second.
Yeah.
It is para 5. Para 3, section 4.
Section 3, where is due diligence in relation to synthetically generated content? Let me share my screen with you.
No, sure,
Let me
sure. No,
let
yeah,
me
yeah, no,
let me know once my screen is visible to everyone.
Yes.
So if we look at this edition, right, where an intermediary offers a computer resource which enables, permit, or facilitate the creation,
What should we
the
say?
at least covering at least 10% of the surface area of the visual display, or in that case of audio content during the initial 10% of its duration. So it is there. And can be used to immediately identify that such information is synthetically generated information, that which has been created, generated, modified, or altered using the computer resource of the intermediary. So that is that 10% has been introduced.
No,
And to
in the, sorry to interrupt, in the present meeting itself, uh, she has edited or modified this original content. It is, this particular PDF is synthetically generated.
no, this is something that is there on the link was there on the.
Selection patterns are there, no?
I've just highlighted it
So
for the
it is,
color.
if you strictly go with the definition, then it is modified.
Right. In that sense, yes, it is modified, because in the absence of, the remains of ambiguity, what is synthetically generated
Yes.
information. So even if I highlight it, it is synthetically generated from a text perspective, of course.
Yes. Sorry, you complete your points.
So Yeah, I mean, this is I think there has to be a phased implementation timeline, which is with respect to images or videos or audios, text, and we need to have a more technical working groups to develop modality specific implementation guidelines.
I just had one question that I think may be pertinent now to ask. Is this going as a recommendation from the members of the panel, or are we like making a suggestion and as the ministry has asked for comments, right? So maybe Abhivardhan would be best posed to answer if eventually the community is trying to make something like that. Because I tell you the reason why I'm asking is because it's a very fruitful discussion that we've had, and uh, the point that came up repeatedly was about the industry not being heard, or let's say other points regarding how enforcement is something that capacity needs to be built for. And that is where I think some uh, something like a like I know there's another organization in India that does this, civis.vote, that allows you to collect, I mean, like they collect your responses publicly and transmit them to the government for suggestions. So uh, at this level, I think Abhivardhan would be sort of best poised to summarize or collect our responses as well. I don't know how, I'm just making a suggestion if that's happening.
No, that's a good point. No, we are doing it. The session is for this purpose. In fact, the hyperlink of the recording will also be shared in the document, like for all committee sessions. The idea is that uh, uh, we will first of all this time we have a deviation from formats. I think with the chairpersons of this session and rest of the ISAIL members, we will collate the points, and maybe I think once the video is out in hours, I mean it will be out by night because it's just uploading, which doesn't take time. We will send it to the concerned ministry via email or howsoever the means have been. If it's a form, we'll just upload it. But I think this time we'll do it in a 2-column format because these people actually are like, "Ha, theek hai." We will read from first column, this is a clause. Then the second column, you have this particular row in which you have this suggestion. So, theek hai, we'll do that. We are open to that as well. Yeah.
So
And
I
I think
believe
we'll
in that respect we can, sorry, I was just
uh,
saying that we can probably have like a shared document where we can substantiate our points from the recording, how they've been collected once the members do it, because I think I want to add more to mine as at least if it's going.
sure. So I think Hamda and Arunima, I think we can collaborate on this. I think just a Google Drive doc will be fine. Formatting is simple. You can just take the recent we published this week with you and you. And yeah, Bahadur has done that, so you can reach out to him for
Yeah,
advice.
yeah.
But it's a simple format. So once the basic drafting is done, you let us know. It's not a transcript anyways. We don't require a transcription for anything on this.
Am I
Yeah.
audible? Hi. Yeah, yeah. So one thing, I just was, just before we end, um, is there any, mechanism, because there's a whole using deep fakes, right? Non-consensual imagery and the personality rights discourse is just happening, right? So it's all regarding celebrities. We have kind of read personality rights into trademark law, and that's the kind of jurisprudence we have right now. But would be interesting to see how, like the deep fake, we are tackling this through social media intermediaries, how we can address, like harms to individuals also, right? Away from this framework. So it's not just celebrities, everybody can, access this, and can complain, these issues.
Actually, I mean, that's a good point. I think the personality rights jurisprudence, as we now call it, technically declared law, it came from some Rajnikant case of 2015 in the Madras High Court, if I'm right. A very old case. This has been taken as a precedent for the Jackie Shroff case. And that inspired a lot of cases, the Nagarjuna case, Arijit Singh case, blah, blah, blah. Although there are some minor deviations on music related rights, and some are related to music, some are related to voice, some are related to face and visual and everything. But I think, well, there are some issues with that too, because personality rights is more of like let us say somebody is an artist and they are giving their rights to an agency, a production agency and so forth. And you know what, you can use my content and I'm licensing it, you're paying me for that. That's how it works. But then creating an additional right like this, can it be correlated with this? There are some problems around the collective nature of civil law and so forth on that, but fine, it's a good point. But I think beyond that, I think it can be still covered under the intermediary liability aspect and the data protection aspect. I think that is more important here, but yeah, valid point raised. Yeah. It can be mentioned. See, everyone can disagree with me. You wish to mention personality rights, it's up to you. I'm
So I
not giving
think,
any point. I'm
yeah,
just
no,
here
I'm
a
just adding
neutral
that as a,
arbitrator.
yeah,
Yeah.
no, that was just a point, but I think as far as non-consensual imagery and everything else is concerned, we already have like that kind of system in place, right? So I think the existing law is good enough to be poised for that. I feel like with another point I want to add was with personality rights and celebrities, at least these techniques would be easier also, right? Because it's just one person and you would have a large enough database of public appearances, and it's one person. It's easier to spot whether it's a deep fake or not or something. But when it's like wide enough, it's tougher. So would be interesting to see how this would interact with this whole like wider like jurisprudence, as I said. Yeah.
Yeah. Before we close, just last point that I wanted to add from my end is, so one thing that seems missing is like the risk-based approach is not taken or considered right now. So the risk which is possessed, let's say by the application or by the usage of content in that application or web platform. So as per that risk, the measures that needs to be taken should be like implemented, and so which is like something that should be coming from the regulator, plus like the decisions by the owner of like the web applications or the mobile applications. So that risk-based approach is very crucial so that we do not have the chilling effect on the like growth of these platforms altogether.
Very true, Chaksu, and I think that we've had a very fruitful discussion, and all the inputs are highly appreciated. And surely Arunima and Abhinavartan, Bhadur, and we all will just collaborate and collate a Google document where everyone can put in their insights and provide a feedback, and we'll try to, mm, frame a document out of it and submit it before the due date. And anything you would like to add to the closing, Abhinardan?
So to the closing, I will say that I'd request everyone to stay for a few minutes after the recording is over for feedback purposes. And second, we need a headshot. So those who can open their camera for just few seconds, including Shruti, if she can, just a request. I think we'll have a headshot and then just put it up. So yeah, stopping the recording, but I think it was a great session, to be honest. So yeah.